our guest speaker, who has given so kindly of her time, Emma Austin. She's an experienced community care and public law solicitor. She's represented clients in several high-profile challenges and to do with cuts in services and support for disabled people. And she's involved in securing adequate support for children, such as our community. She's joined the Central England Law Centre in 2016, and her work's been focused on public legal education projects, such as the Peril Project and the MAC Project, the Mother and Child Project. So she's now in the lead on development implementation of integration of the Law Centre's rights and community strategy. So working with us tonight is just a part of what she does. So she's going to be talking to us tonight in particular about the Down Syndrome Act. So I am going to stop my sharing and welcome you, Emma, up onto the stage with me. Hi, Emma. Thank you so much for joining us this evening.
Oh, thank you for having me. I'm going to try and share my screen now. So I have a presentation for you. Just try and get that up. You can let me know if you can see that.
Yes.
There we go. We got that up. Fabulous. I'm not going to be able to see you all, so please do shout if you've got anything to say, or you need me to pause or go over anything, as I won't be able to see you when I'm going through. So I'm going to talk about how the Down Syndrome Act fits into the existing social care legal framework. Just a tiny little bit of background about us as an organisation. Thank you for the introduction. We as a law centre are a part of the National Law Centre network, and we have our base at Central England Law Centre in Coventry and Birmingham. And we're a charity providing free specialist legal advice across a range of welfare, social welfare areas of work, but probably the most relevant for your purposes is health and social care and public law. And it's in that capacity that I'm going to be talking to you tonight. So I'm going to just run through very, very briefly, because it's absolutely enormous, how the existing social care legal framework works, and talk about the really key functions that local authorities have towards children with disabilities, adults with disabilities, parent carers and carers of adults with disabilities, and then look at how the Down Syndrome Act fits into this existing framework, look at what the change that the guidance from the Down Syndrome Act will bring to that existing framework, and then look at opportunities that gives you as a community moving forward. So, as I said, it's a very extensive legal framework. It really is. Local authorities have a huge number of duties and legal powers, which we're calling social care functions, because that's the language that we'll see in the Down Syndrome Act later on, towards children who have disabilities. And by children, we're talking about anybody under the age of 18 years, including young people, children who are transitioning to adult services. So those who sit in that sort of horrible period between childhood and adulthood, where sometimes services can be quite inconsistent. Local authorities have several key duties towards that particular group of young people, as well as duties towards adults with disabilities and carers. And the law is found in a number of places. Firstly, in legislation, and by that I mean acts of parliament. Now, this is really important because it's these acts that create the legal duties and powers that public bodies, such as the local authority, have. Public bodies, unlike you as private individuals, can only do what they've been given an express legal power or duty to do, and they're given that express power or duty by acts of parliament. So that creates the scope for a public authority to do something, to take an action, to do anything. Without an act of parliament giving them that specific power or duty, public authorities can't act. So it's the kind of opposite of you as private individuals, who can do anything that you want to, as long as it's not illegal as long as there's not an act of parliament saying you can't do it. For public authorities, they can only do what they've been given an express power to do. And that power or duty comes from the act of parliament, the primary legislation. And in our area of law, and in relation to the Down Syndrome Act, key bits of legislation are going to be things like the Children Act, the Care Act, the Chronically Sick and Disabled Persons Act, the Children and Families Act, and the Mental Health Act. We also then have law that comes from secondary legislation, and these are bits of further law that flesh out the detail of the overarching provisions that are in the main acts. So these include regulations, directions, statutory instruments, and the community care services for carers and children's services regs, direct payment regs, set out detail as to how the Care Act and the Children Act work in relation to provision of support to people with disabilities. The care and support eligibility criteria regulations provide us with key information, further detail that tell us how the Care Act should work. And the breaks for carers of disabled children regulations, really important little bit of law that helps us understand how parent carers should have a break from their caring duties. We then have more to our legal framework. So we have guidance, and this is really important because this is where the Down Syndrome Act sort of will fit in a minute, or what will be produced by the Down Syndrome Act will fit. Guidance tells us how public authorities should comply effectively in practice with the legislation. So with that, the Act of Parliament, and then with that secondary legislation, with the regulations, the statutory instruments, the directions. So they provide the kind of the blueprint, the instruction for how to implement what the overarching legislation tells public authorities that they need to do. And the last place that we go to for the source of our legal framework is the common law. And by that, I mean judge-made law. So in this country, we live in a common law jurisdiction. And what that means is that when deciding cases in the court, judges make decisions that are then binding in future cases. So they interpret the law, they consider what's meant by the primary legislation, what's meant by the guidance, what's meant by the regulations, and what the court decides in one case, we can then use as a precedent in another. So lots of the law in the social care arena is made by judges interpreting the overarching legal scheme. So key duties that exist under that legal framework. There's a bit of a pattern here for children, adults, and carers. So I'm just going to pick out those kind of key duties. These are not all of the duties that are owed, but just some really, really important ones that you need to be aware of. So local authorities have duties to assess the needs of children and young people who are transitioning to adult and children with SEND. And that means to look at what the individual child needs. So to have a look at how their condition affects them and how it impacts on their ability to manage day-to-day activities, personal care, accessing the community, a kind of a wide range of daily life skills. The local authority then has a duty to make a decision about whether any needs that have been identified in the course of an assessment call for the provision of social care support and services. This sounds really obvious, but that duty to actually make a decision at the end of an assessment is one which it doesn't always happen, and sometimes people end up in assessment processes that go on forever and ever and ever. And actually there's that really clear crystallised duty for local authorities to use the information gathered in an assessment to actually make a decision about what somebody needs. Local authorities then have duties to develop support plans to provide support that's relevant to meet the needs of a disabled child, and then have to go on to actually provide those services. Local authorities also have very significant duties towards disabled children in respect of safeguarding. Similarly for adults, got that same pattern. So key duties would include duties of the local authority to assess the needs of adults with disabilities and to make decisions about whether those needs call for the provision of support by the local authority. In the adult social care context, local authorities have to consider whether the needs are what we call eligible needs, and that means whether the needs reach a threshold at which the local authority is legally obliged to provide support to meet those needs. So the thresholds are slightly different in children and adults law as to when the local authority has to step in and provide help. Local authorities have duties to develop care plans, to provide support and services as set out under the care plan to actually meet any eligible needs. And similarly, there are duties to safeguard vulnerable adults. For adults, there are also a number of key duties that come from the Care Act that local authorities have to provide advocacy, to help adults navigate these other processes, the assessment process, the support planning process. There are duties to promote well-being, duties to prevent needs from developing or from becoming more acute, and duties to integrate with the NHS and other relevant partners, be that education, the police, etc. There are other duties that require local authorities to provide information and advice to help adults with disabilities or their carers navigate the care process, to offer a range of services and to be able to identify those, for example. And local authorities have duties to what we call market shape, and what that means is to ensure that in their area they're commissioning a range of quality services which provide individuals with choice about how their care is provided and the sort of service that they can access to meet needs that they have. For parent carers, again, we've got the same pattern, key duties to assess needs, to make decisions about whether needs call for the provision of support by a local authority, duties to develop support plans and to provide support and services to meet plans. And for parent carers and carers, particularly important services are short breaks and respite. Local authorities similarly have duties to carers to promote well-being, prevent their needs from developing, and that can be their needs or the needs of those they care for, because often carers end up, sadly in my experience, developing needs because their roles can be very demanding and can sometimes lead to carers' own health or well-being deteriorating. So there's that really important duty there for the local authorities to prevent or to seek to delay needs being developed by carers, and similarly to provide information and advice. So how does, let's skip the slide there, how does the Down Syndrome Act fit into this framework? Well, the Down Syndrome Act is a very short piece of legislation with only a couple of key sections really. The first being a duty placed on the Secretary of State for Health and Social Care to issue guidance to relevant authorities on appropriate steps for them to take to meet the needs of persons with Down syndrome in the exercise of their relevant functions. So it's a very legalistic provision there. Essentially, Health and Social Care Secretary needs to issue guidance to authorities such as councils, so such as local authorities, and that guidance should set out how people with Down syndrome should have their needs considered in the course of the functions that public authorities exercise, and that includes, for our purposes, social care functions, including those key duties we've just looked at towards children, adults, parent carers and carers. The second major provision of the Act then is that after that guidance has been issued by the Secretary of State for Health and Social Care, public authorities, the relevant authorities, including local authorities, so social services, have a duty to have due regard to that guidance in the exercise of their functions. So when they're carrying out all those social care functions under the legal framework, they need to have regard to the guidance issued under the Down Syndrome Act. Now, due regard does mean that those public authorities have an absolute duty to follow each provision in the guidance. They can depart from the guidance if they have sensible, rational reason to do so. But due regard means that the Down syndrome guidance is going to be a relevant consideration that they should take into account when exercising their social care functions. So they can't ignore the guidance entirely, and if they were to do that, that would in all likelihood be unlawful. Due regard means that the guidance that's issued under the Down Syndrome Act has to be considered alongside and in cooperation with the existing framework. So in cooperation with the key provisions that we have from the primary legislation, from the Acts of Parliament, like the Children Act and the Care Act, from the secondary legislation, like the Care and Support regulations, the guidance, like the Working Together guidance that we have under the Children Act, and the common law. So the common law isn't displaced, it doesn't go away. The new guidance that's going to be issued under the Down Syndrome Act fits into that framework, so it forms part of this kind of existing network of provisions. And we don't know exactly because it hasn't been set out, but we're expecting as lawyers for the phrase due regard to be interpreted in the same way as it has been under the Equality Act, where the courts have said due regard means that local authorities, public authorities need to have regard that's appropriate in all the circumstances. So they need to use the guidance proportionately. They need to be kind of taking it into account so far as is appropriate in the exercise of their functions. What does that mean in practice? Well, it means that when the local authority, when councils are exercising those social care functions, they need to take account of the practical suggestions, the steps, the proposals, the best practice, the tips that are put into the guidance on how to operate in a way in the exercise of their functions that is mindful of the specific needs of people with Down syndrome. And that means when they're doing assessments of children, of adults, of carers, when they're making decisions about needs, when they're safeguarding, when they're promoting wellbeing, when they are market shaping, so they're looking at commissioning services, they need to be doing that through the lens of what the guidance sets out about how people with Down syndrome, are best supported. What that really means is that the guidance, if it's good, if it's comprehensive, if it's detailed, if it's practical, has the potential to improve social care processes, everyday social care processes that people with Down syndrome and their carers have to encounter. So those day-to-day really important functions, those assessments, those support plans, that the packages of support that are put in place for people, those can be improved if the guidance can be pointed to and can be used to draw out, well, how could those processes happen more effectively? How could they be more sensitively carried out? Hopefully that will lead to support being better tailored in the long run to the specific needs of people with Down syndrome and their carers. And what it also means from a legal perspective is that where councils fail to take account of the guidance without rational reasons, whilst they're carrying out their social care functions, whilst they're exercising all those duties that they have under the legal framework, that could be legally challenged. So people with Down syndrome, their carers will be able to sort of bring challenges if local authorities aren't operating in a way which is consistent with the guidance and can't provide, sensible, rational reasons as to why they're doing so. For you as a community, there's a really significant opportunity here. Firstly, to actually get involved in shaping the guidance. The consultation on what's going to be included in the guidance is live now. It closes on the 8th of November. And the government is under an obligation under the Down Syndrome Act to consult appropriate persons. about what should be in the guidance. Well, you are the appropriate persons. You're the experts by experience. So please, please, please do participate in the consultation. I know that Peter is going to be talking to you about how you can go about doing that shortly. But it's really, really important to, you know, to get your views across, to make sure that the guidance, you know, has the opportunity to consider what you know about how those processes work for your own families and for the families that you support. I'd say sort of tips would be to make your suggestions for content for the guidance as practical as possible. Provide best practice examples, provide case studies of things that have worked really well, case studies of things that really don't work well, tips as to how, you know, how social workers might be engaging effectively with your family. And in doing so, you stand the best possible chance then of that guidance, you know, that information that you provided being incorporated into the guidance, and that guidance then actually being useful. It provides a kind of I've used the word blueprint, you know, earlier, but it provides a blueprint as to how social services can work better to support, you know, your families and your community. There's also an opportunity later. So once that guidance has been implemented, you can refer to it when you are in the course of engaging in sort of particular social care processes. So if you're mid-assessment or support plan, or you've got a care package that doesn't really work very well, or the kind of support being offered isn't really appropriate, but you can point to something specific in the guidance, it gives the local authority the opportunity then to be looking at it and thinking, well, actually, perhaps we could be providing support in a different way, or perhaps we should be doing something differently. And as I said, if they disregard that guidance entirely, can't provide a sensible reason as to why that is, that could potentially be challengeable. And if local authorities are disregarding the guidance, they're not operating in a way which is consistent with the needs of the Down syndrome community, then it's open to individuals to be seeking advice, legal advice, and potentially challenging the council, because the council's failure to take account, to give due regard to the guidance, may well be unlawful in their circumstances. I think that's everything that I wanted to say. I'm happy to sort of stay on the call for questions. So if I stop screen sharing now.
Thank you so much, Emma.